It being 7:35, we'll call the meeting of the Scituate Planning Board on Thursday, June 27th, 2013, meeting to order. The first thing I need is a motion to accept the agenda.
So moved.
Do I have a
Second.
All those in favor?
Aye.
Thank you. First item on the agenda is a continuation of the public hearing and the opening for a scenic road public hearing for 305 Country Way. It's a flexible open space special permit and definitive subdivision plan and scenic road we're reviewing. Let me, before we go too much farther, explain to you what the situation is going to be in terms of voting members. Bob was not present at the first meeting and not present at the second meeting, so Bob will not be a voting member on this. The voting member would be Richard. Richard, when he comes back, will comply with reviewing the tapes, the documentation, and he will sign for that. So your voting members will be the standing members of the board. Okay. So you'll have 4 of them here tonight, not having 5. So where you're required to get a 4/5 vote, you may want to consider the timing of that vote to have either the five members present to make sure that you've got them. Okay. Now, having said that, let's talk about what we're going to do. We'll let you give us an update of what's transpired since our last meeting. I will ask John to come back up and give us his review. We'll then ask Laura for comments, questions from the board, questions from the public. We'll do that all within an hour.
Do you want to read the ad for the scenic road?
Let me comply with the legal requirements here. Notice of public hearing for Scituate Planning Board. In accordance with MGL Chapter 40, Section 15C, the Scenic Road Act, and MGL Chapter 87, Section C, Public Shade Trees, the Planning Board, in conjunction with the Tree Warden, will conduct a public hearing on Thursday, June 27, 2013, at 7:30 in the Selectmen's Hearing Office, Town Hall, 600 Chief Justice Cushing Highway, Scituate, Mass. The subject of the hearing is removal of the following trees in connection with the construction of a proposed development of 3 lots called Fred's Way, definitive flexible open space development subdivision at 305 Country Way. Assessors map 37-2-2 and 37-8-13R. For applicant Douglas E. Sharon, 1 18-inch red maple, 1 12-inch Norway maple, 1 6-inch American elm, 1 3-liter 10-inch, and 8-inch black cherry, and 1 10-inch black Norway maple and brush smaller than 3 inches in diameter. Plans are available for review in the Scituate Planning Board, Office, Town Hall, 600 Chief Justice Cushing Highway, Scituate. Butters and other interested parties are invited to attend this public hearing. Signed by myself and posted 6/7/2013. Now I think we're legally ready to proceed.
For the record, my name is Gregory Morse. I'm a registered engineer, Morse Engineering. With me is attorney Michael Hayes and my client Doug Sheeran, the property owner and applicant. Since the last meeting, we revised our plans. The latest plan revision date is June 6th. We sent copies to this board. We sent copies to Mr. Chesia for his review. We made our revisions based on John's first review letter and also from comments from the planning board. We've received his second letter, and we will address the comments on that in another revision, which we expect to get out next week. We'll also take into account any comments the board has tonight. The first thing I'd like to start off with was the conventional density plan. We made a couple of revisions to that. The conventional density plan, as you know, for the flexible open space development, you're required to come in with a plan showing conventional yield and lot layout. That's what this plan depicts. It depicts, as shown, 3 house lots, 1, 2, 3. All of the lots comply with respect to zoning requirements. They comply with setbacks to the side and rear and front yards. They all have the requisite 60 feet of frontage on the cul-de-sac or 100 feet on straight portions of the roadway. They all have the lot width of 175 feet through the building, and they all have at least a minimum of 40,000 square feet of upland area. They comply with zoning 100%. We added to this plan some data that John had requested. He had asked us to add soils information. You'll see that we have soils data in a chart table. We also have the soils maps as shown on the SES soils that was added to the plan. The layout itself, we removed a common driveway so that each lot now is serviced by its own separate driveway. Each lot has perk tests on it. The Board of Health has reviewed this and approved this layout at one of their Board of Health meetings. We have acceptable perk test data on all 3 lots as currently shown. The drainage system is out on the street. The drainage system is very similar to what we'll be building with the flexible open space, but as we know, the topography on the site drains from Country Way to the rear of the property, the wetland line shown in blue. What we're proposing for drainage is a series of catch basins. We have them gray-scaled on the plan to a drainage basin. And we feel that the sizing of this drainage basin is correct. We have sized it at 8,500 square feet for a 3-lot layout. And in retrospect, with the flexible open space development, the plan that we've actually run all of the full drainage calculations, that basin is only 5,500 square feet. So I'm allowing 8,500 square feet for a conventional layout. So we feel that there's adequate area for stormwater. This complies with the 150-foot no disturbance zone, which is shown in orange. Here, we're not proposing any work within that zone other than the removal of the barn or removal of the house, which, as you are probably aware, are both been removed from the site at this point. I'd open it up if there's any questions on this plan or anything further that you'd like to see. We added the grading was one of the things that John had requested. We've added grading throughout the site as well.
Okay, thank you. John?
I think the only thing on this, just for the record, as far as what I do for my reviews, hopefully read them, I know they're lengthy. I list every section of the regs and whether or not it complies and if there's something there. So some of the stuff that was added that they asked for was just strictly in the regs. Soil information, things like that, was on other plans, but it's required under the regs to be specifically on this sheet. I think the issue on this plan, if there is an issue on this plan, this is for the board really to decide, is there's a retaining wall inside the right-of-way here, which isn't allowed, and I think there's a retaining wall along here to make the grades work. The cross-section, I believe, the section of the regs requires the retaining walls be outside of the right-of-way under the construction standards, so I think that could be an issue there, whether or not they can fit, and I'm not familiar with what's been done with retaining walls in Scituate before on subdivision roads. Obviously, this is a theoretical exercise, but I think that's the only issue I think I see with the conventional is the walls and the ability to construct them. It's obviously very tight, the line's right up against it. To put a wall in, you have a footing. You're not asking somebody to design a whole wall here, but the board's gonna have to decide whether there's enough information, I guess, to say, can you or can't you fit it?
So we do have one retaining wall proposed at that location. The height, the top of the wall is at elevation 86. The bottom of the wall is at elevation 84. It is 3 feet within inside the right-of-way. I can certainly move that exterior of the right-of-way.
Actually, there's a wall right here, all the way along.
There's no wall there.
Yeah, this is 90 and the grade right there is 85.
I'll have to review that.
So, I mean, to build it, I think that's the issue I see, whether you can build it, fit it, and comply with all of the requirements of the, because the section says you have to build a certain type of wall, it has to comply with the DPW requirements. And I don't know what DPW requires, it's either, it says, concrete, masonry line, 5 feet high, 4 feet high.
Wouldn't that second piece of wall that you're referring to be outside the no disturb zone, or not?
It's right along the edge of the right-of-way.
Everything runs right along that edge.
It's
Well,
right, this wall runs in
This is the
here.
no disturb, right?
Yeah, I guess the question
So-
is, can you actually put a wall there?
Right, without going into the no disturb.
Yeah.
Okay.
And that one I would have to come outside the right of
Yeah.
way, which I don't, I mean, this
Is
is,
this it here?
Yeah. No, I see that one. I was referring to the second piece up here. It looked like it
I mean, yes, this
might not
one's-
be such a conflict.
this one's like 5 feet high here, then it gets less because the grade's sloping down,
Mhm.
so it buries into nothing somewhere up in here, plus the disturb zone goes away. It's really this spot in here that's
Okay.
the tightest, and that's where it's kind of, but I think the wall runs from here to here, but it doesn't really, it's not really labeled.
Right,
I
right.
mean-
You have to look at it,
Just
look
the
at the
difference
grades in
elevation
order
before you
to,
pick it
Well, you can see
And
it's
it-
thicker
yeah,
there.
This is sort of a theoretical exercise.
This
but
line is
that's-
thicker.
That's
Hmm.
the issue I see, if, you know, the board has to take a look at that, what would typically be done for a wall, and can you fit it?
Other than that, can I build it? Could I build this?
Other than that, I would think so, yeah.
can't you do the type of footing that would be back towards the roadway itself, and actually the wall would be held up by the weight of the earth on top of that footing?
I think that you have to do what the DPW would require,
Okay.
right?
So-
Because if theoretically, it could ultimately be put up for acceptance. And that's what the regulations say. Now, I
Okay.
know that this one may not be desired to be put up for acceptance, but I know the town meeting can vote whatever it chooses to vote. So-
Okay. And that's a symmetrical footing, more or less.
Well, what it says is the things which required to be, a retaining wall of stone, brick, reinforced concrete, or other suitable material satisfactory to the planning board, actually, it says, so, although usually you go deep up. So whatever you think is an acceptable wall, and if you think it fits, that's your decision to
Okay.
make. I'm just raising it up as an issue that you need to then decide.
I know we've done them that way.
But in order for it to become a town road, it would be reviewed, and could potentially have to comply with design requirements of the DPW before it could be accepted, or there would have to be some kind of betterment happen to modify that road.
I would, yeah, usually if you're gonna have a road go for acceptance, the DPW would go out and look at it and say,
Right.
we don't like this, or we do like this, and, you know, if it's designed from the very start to be put up for acceptance, then it would make sense to talk to them before you build it as to what they want.
But I think we have a note already from the DPW that says the width doesn't comply either, right? So,
Let me see if I can address it. Put on my street acceptance hat. The current process of looking at it is the benchmark is current subdivision standards is before it's accepted. So we come back up and it's been looked at as to what does it take to bring it up to current subdivision standards before it's accepted. And to the extent that the street acceptance may come back and sit there and say, well, I really don't need a sidewalk, or I'll waiver a sidewalk. They've been able to do that. But basically, they've looked at pretty much the width and the construction techniques of the road to come back up before they would come back up and go forward with it. And if it didn't comply, then in effect, what they would have to do is to bring it up to compliance, they being the homeowners.
There have been some roads accepted, though, like Blossom Street, I think, was one, which
Oh,
was a
yes.
really old subdivision. Cornerstone Estates, which was a lot more recent, that didn't really meet subdivision regulations at all.
Understood.
Whether that's good or not, I don't know, but,
I'm just telling you what the process is.
yeah.
So, we all set, John?
Yeah, I mean, from what I understand reading the regs, I bring it to your attention, it's your, what you
Okay.
think is something, if you think that's something that's, whatever the wall is that's acceptable, you have to decide. I'm just
Okay.
highlighting it for your deliberation.
I appreciate that. Laura?
I guess one of the main points I wanted to make is, and this isn't intended to be, you know, a critique of this plan or any other plan, but there's been a lot of discussion here recently with several applications about the applicant having certain rights and the zoning bylaw, you know, granting certain rights. And I know, you know, property rights is kind of a hot button issue sometimes, but the way the zoning really is supposed to work is that the special permit is discretionary, and you do have some say about whether you think this number of lots is really reasonable for this property. You know, if you didn't have that discretion, there wouldn't really be any need for a planning board. So so I think that's real, and I just, wanted to make sure that everyone knew that. That being said, I think that in some ways this does seem to meet the letter of the law as far as zoning is concerned, but when you look at the road that's proposed, the layout actually, it's right on top of that 150-foot no disturb line. So I just question whether it could really be built without any disturbance in that area. And I think that's something the board needs to evaluate. One other concern looking at this plan is when you look at Lot 1, to get the required area, it needs some of the back land. And the little strip along the southeastern side of the lot, most of it, I believe it's about, it's maybe about 8 feet or so through the length of it. But right at the cul-de-sac, it seems to shrink down to about 3 feet wide. So I just wanted you all to be aware of that. I mean, in my way of thinking as a potential purchaser of a lot, would that be realistic? To buy a lot with a shape like that. I think that's something you really need to think about. And otherwise, the only other thing that's a slightly iffy is when you look at Lot 3, there's not much space on that lot because of the no disturb. And to get the septic system to fit on that lot, you had to make, maybe a quarter of that house be set on a slab. And I think you got to also kind of consider, is that really realistic in today's market, that someone would buy a house in this area, these market conditions and so on, where it's on a slab as opposed to a full basement. So, just some things to think about.
Okay. Questions to the board? Bad news for you, Rick.
I'm going to defer.
Richard's not here.
Yeah, I know. I'm going to defer.
We know that Richard is around because we got emails from him, but
Yep.
I think when we came here before on this issue, I'm not happy with this. The work that's been done is elegantly done. But again, just because we can doesn't mean we should. And I look at how close this driveway is to the property line. I look at the fact that we're having to encroach on the no disturb zone just to get that wall built and the driveway put in. The gerrymandering is elegant, but it's gerrymandering. That's what I say.
okay. Robert?
I certainly see everything that everyone else sees, that this is a well-engineered plan that does meet the letter of the zoning bylaws. And I'm also aware that it's really a paper exercise in order to get to a flexible open space plan, which is much less invasive of the site. So in that sense, if somebody were coming in to say they want to build this plan, and please give me permission to do that, I might be very tempted to say no. At this point, I think I'll defer my opinion, yes or no, to the rest of the board's discussion. I can't make a judgment at this time. I don't believe that I have grounds for objection, to tell you the truth, at this point, to this plan, under the circumstances.
Steve?
Well, I would echo comments of my colleagues here. I'm particularly concerned about the impact on the no disturb area, because I don't see how you can build that roadway without disturbing that area. Retaining wall, just grading and putting putting a road in there, so I would say that would be sort of, if somebody came and asked me to build this, that would be my primary concern, is doing that. I think Laura's also pointed out a couple of other issues with respect to how the lots are designed and the kind of proposed construction that I think have some merit as well, so I think I will defer to seeing the other pieces of or hearing the other comments, and then we can talk about it from there.
You're a non-voting member, or be non-voting on this one, but look for your input.
The rat tail design, I've just never been a fan of that. It's, again, on paper, and I think I have the most current one. I'm having trouble seeing the driveway for, you said you had separated them, and I saw these two.
Yeah, I've actually got two separate, they come together at that point.
Oh, okay, all right, so they do, so they are common right off the cul-de-sac, and then they separate, okay, because that's what I was trying to find. Okay. I didn't know whether there were two next to each other off the cul-de-sac. But those are my concerns, the rat tail design, and on paper, it's kind of, shoehorning it in where to abide by the bylaws. I don't know with the setbacks what's possible to move or to do, but there's not a lot of room to work there. Thank you.
Yeah, I guess what you've got is a rather difficult piece of land here. You're driven by the do not disturb. And then, at least in my own mind, I can separate what, and I think that was the reason why I asked John Fisher, is whether that could be built or not. Because if he came in with that plan, you'd get at least one no vote for me on it. In that, but separating that from an exercise, which really is what the flexible is to create a conventional subdivision that would come back up and identify what could be built on that piece of property. And I think that, given the level of engineering that we've got, I think you can probably build most anything on most any piece of property. And I think they can be creative enough to come back up and make it work. But there is a distinction, and I think that the board is grappling with it, as to what could be built as opposed to, once I've created that capacity and determination of the number of units, which can I provide a layout that's significantly better than the conventional. And I think that's the case, and I think you see that in the rest of his plans. But you also see, I went through all of John's comments, there's a great deal of issues in terms of drainage and a lot of other factors that talk about the entire project as to whether it can be built, and it leaves the discretion back here to this board. At some point, the board's going to have to make a decision whether that is or a conventional subdivision that allows the applicant to get his 3 lots, or it is not an acceptable conventional subdivision that would give them whatever they could come up with with a subsequent attempt. And I think you're going back to why I referred to the fact that you need 4 out of 5 and you've only got 4, at least 4 voting members here.
I definitely understand some of the concerns that you brought up, and I think we recognize here on the applicant's side that this is not the preferable layout by any means. We believe that we can provide the data to show that we could build this, but it is not what we're preferring, it's not what we're proposing. And when I get into the flexible open space here, a lot of the concerns you just talked about, I think, will disappear.
Can I mention one other thing, Bill? The common driveway for lots 2 and lots 3 that's proposed,
Eliminate that.
well, the reason why I think there's an issue with that is that there is a part of the zoning bylaw that says that you can't do a common driveway off of a cul-de-sac. And I'm not saying it's never been approved, but, the bylaw does kind of specify that.
We can certainly eliminate the common driveway because we have plenty of access here for this lot over its own frontage. You can go over the septic system, there's no issue with that. So
Okay.
I would change that on the next round.
Further comments from the board?
I do have a question, just about the drainage. You said it's 8,500
Correct.
and suggested that the flexible space plan is much smaller. Why is it 8,500?
Well, there was a question.
I'm assuming it's
Without-
designed to handle the flow that comes in.
Exactly, without running a full set of drainage calculations and drainage analysis reports on this layout, it's hard to come up with an exact design without doing all of those calculations. We did all of those calculations for our flexible open space. And the flexible open space, based off of that 100-year storm event, required a 5,500 square foot basin. Knowing that, on this one here, we're saying we've allotted 8,500 square feet on this. So knowing that we're gonna get a little bit more runoff off of this probably as it's a constructed cul-de-sac and not a hammerhead style, we've added some area to that basin.
Yeah.
Questions from the public?
Move on to the flexible open space.
Well, before we do that, let's see where we are with the conventional.
Okay.
Because if we don't have concurrence on the conventional, then I'm not sure that at this point we need to go farther.
Sure.
So what's the pleasure of the board?
Speaking for myself, I would like to see the flexible open space plan as a comparator.
Okay.
All right, I'd like to sort of have those hand in hand and be able to look at what the alternatives look like.
To see the cause and effect. Okay. Board concur?
Yeah, I'm willing to accept that the conventional thing that we're looking at, conventional plan that we're looking at right now is theoretical. And I agree, if the flexible open space is more acceptable than this, let's look at it. But I don't want to commit saying at this point in time, yes, you can build 3 lots. I'm not going to do that.
I would concur with that. I think that's where I am too.
Okay. We got a sense of direction. Talk to us about flexible.
So the flexible open space layout. I'll start with the lot layout plan. We reconfigured lots based on our last discussion with you. When I was in front of you before, a large portion of the 150-foot no disturb was kept as part of lot 2, part of lot 3, and the board expressed interest that they wanted as much of that area designated as open space and taken over by the town as possible. And so you'll notice that we reconfigured all of the lots 1, 2, and 3, so that all of this area now is part of the open space. The major advantage of doing the flexible open space development plan here is the open space calculations. Per the bylaw requires 111,816 square feet of open space. This plan preserves 283,568, 2.5 times the requirement of what the bylaw specifies. And furthermore, the upland area that's maintained by this plan, the bylaw requires 78,271 of upland. We're providing 96,084, 122% what the bylaw requires. So that is one of the largest benefits of doing a flexible open space here, is the preservation of this entire area. This plan here, other revisions that we made to it. We added on lot 1 a site distance easement across the front, right here. I'll get into site distance on the next plan, but to maintain site distance, we're proposing an easement where we will not have any trees or any walls or structures placed within that to comply with site distance requirements. We added our survey traverse. We provided our closure errors. We added all of the additional monuments that we found along the property corners, iron pipes, bounds. We provided all the closure calculations as required. Our grading and utility plan, we met with the fire department to talk about our hammerhead access. Deputy Murphy has signed off on the hammerhead access. We met with him regarding the hydrant location. He's signed off on the hydrant location. We have a hydrant at the end right here. We also have an existing hydrant at the corner of our property on Country Way. We went to the site with the water department. We conducted hydrant flow testing. There's adequate pressure, there's adequate flow at this site to support this development. This layout here shows what the site distance is at the intersection of Country Way and our development. This blow up here specifically shows that Country Way has a posted speed limit in both directions of 30 miles per hour. Per AASHTO, the 30-mile-an-hour limit requires a stopping site distance of 200 feet. This site has 200 feet of stopping site distance in both locations, to the left and to the right. Your regulations further specify that on streets that are classified as a major street, which Country Way is, that we're to go out and take speed records of some of the vehicles out there and use the 85th percentile speed for establishing a distance. We did that. We took speeds on 50 cars that went by the site, and we found that the average speed was 40 miles an hour. Okay, so there's a speeding problem out here. The 85th percentile requires 305 feet of sight distance. This line here represents the 305 feet, which we comply with. In order to comply with that, we've had to take down a couple of trees along the front here. Those trees we also submitted as part of our scenic road application, and we've spec'd out the trees that are within the right-of-way that need to be removed to provide that safe distance. The neighbor's property, primarily lawn up to the front. The closest point that they have is a large tree here. We get by that tree and all obstructions to comply with that 305-foot setback in that direction.
So that tree stays?
That tree stays. All the trees we're touching are on our property or directly in front of our frontage. This grading plan was also revised. The board expressed the want for a sidewalk. We that waiver. We now have a sidewalk that connects from Country Way down to the end of our hammerhead that will eventually, tie in. At some point, Country Way is going to have a bike path. They don't have a design for that yet. I don't know if it'll be on our side of the street or the other side of the street. Another point of the bike path is if they're going to be reducing lane sizes in Country Way and accommodating this bike path or putting up guardrails, typically that will generate lower speeds as well. And so the mile-an-hour rate that we're seeing will be further reduced, hopefully down to 30 where it's supposed to be. The water system, we proposed a looped water system. We're coming in with an 8-inch line, connecting through to Country Way. We provided individual driveways on this plan, each of the lots, lot 1, lot 2, and lot 3. So no common driveways proposed whatsoever with this. The layout we had previously, you probably remember, had a common driveway running along this property line. There was very little buffer, and one of the neighbors had mentioned something about headlights. Now, while our driveways are further off the lot line, we're able to maintain some natural vegetation along that lot line to the abutters' properties. Lots 2 and 3, we've tried to separate out and make it so that each one will kind of have its own backyard. Previously, the 2 houses were directly behind each other. With this type of configuration, I think that there's potential here to make some privacy and have some better utilized backyard space. We revised the detention basin. We made the detention basin longer and skinnier. This is the detention basin area here. We provided the berm around it. Drainage for this project is picked up again by a set of catch basins out in the right-of-way. It traverses down to a particle separator and then discharges into the basin. The revised grading on this, all of the grading on this site complies with the 4:1 requirements of the Water Resource Protection District. We have the basin graded out at 4:1 around the berms and on the interior as well. And I specifically referenced that because there was correspondence submitted from Lance Van Lenton and William Trussell in a letter dated June 24th, and I want to specifically say that their 2 statements are false. We comply with the 25-foot or 25% grade requirements.
I wasn't sure what that was.
I haven't found 25% grades on this site.
And so, where's the grade of the 25%?
Yeah, there's one off the driveway, and I know, it says that slopes associated with the driveway sidewalls can be 25%. But the outer slope appears to be more than 25%, or at least 25%. And there are at least 3 other spots that we saw. I mean, I can send you the plan with those spots marked.
Okay, yeah, if you can do that, because
the other thing is that, the bylaw says that the non-disturbance zone buffer bylaw says that stormwater runoff can't be discharged into the non-disturbance. And all along the side of the project is a slope that'll be created from this development, and that's going to be shooting stormwater into the non-disturbance zone. Can't avoid it. Basically, the whole project's on a mound of dirt, so it's going to be shooting water right into the non-disturbance zone.
Wouldn't answer that.
All of the water created by our roadway, our houses, and our house lots, we have a berm built along the side of the road here. It's trapped and directed toward our drainage system. The drainage system discharges over here, outside of the non-disturbance zone. You are getting surface runoff into that zone. You get that currently. A large area of town, surface runoff, is running down, it runs through and runs into this drainage system in a larger scale. But all of our road runoff is collected, it's treated through the basin, and discharged outside of the disturbance zone.
So explain that to me again on that west side of the road, closest to the non-disturbance zone.
Yeah.
You're
This-
building a berm?
So right along the edge of the pavement, so all of our surface water coming from the street is all treated. You're gonna get the vegetation.
What kind of berm is this?
Cape Cod berm.
This is a Cape Cod berm, so this is an asphalt berm you're
It's an
talking about.
asphalt berm.
So how's the roadway tie into the existing grade on the west side?
It's a grass embankment from the back of that berm down to what grade is. So you're gonna get runoff from that grass embankment, but we're not creating a discharge point. That's surface runoff. Surface runoff runs off from everywhere.
And how steep is that?
The embankments here,
Mhm.
I believe, are at 4-1, but I'll double check. They're allowed to go up to 3-1 if they're associated with a new roadway. Yeah, right here, those are 3-1, but that's allowed with a new roadway, it specifically says that. It's elsewhere on the site, as we look at the front yards, the rear yards, anywhere on the lot associated with the lot grading, you're not allowed to have greater than a 4-1 slope. Along the roadway, we have 3-1, which is specifically allowed. This layout, we developed a revised plan and profile based on the layout here. In the plan and profile, we spec'd out street tree plantings along the right-of-way, along the back of the sidewalk. You see the sidewalk here. Here's the roadway layout. The roadway is a 16-foot wide paved roadway cross-section. Waiver for the pavement thickness, the 3 layers of asphalt that the planning board requires for paving. We added a landscape plan. Again, we're speccing the street trees being placed along the right-of-way here. This area here is going to go back as natural vegetation. That's all being conveyed as part of the open space. And we're proposing arborvitae along this property line here, an evergreen, to help shield the neighbor's property.
How close to the do not disturb line are you building to?
What we're proposing to do is to put an erosion control device along the 150-foot buffer and work up to it with grading.
And it gives it adequate protection?
Sure. What we're gonna do is we're gonna have a straw bottle that'll be placed out there along that 150-foot buffer, that will be staked. We can certainly add a silt fence to it as well, to help really define it if you want.
So when you're completing construction, how far off that line are you?
150 feet. We're working up to the 150-foot no disturbance zone.
So you'll be right on the line.
Correct. The driveway itself, or the roadway, is off of the line. It's the grade that you're making up from the roadway down to the existing grade there. The roadway is approximately 15 feet at its closest point to the no disturbance zone through here. That no disturbance zone is currently grass vegetation all through this area. We'll be installing new grass vegetation in the areas that we disturb, that again, will all be outside of that 150-foot buffer. We developed an erosion sedimentation control plan for the site. This is more of for during the construction phase of the project. The erosion sedimentation control plan, they'll have a stabilized construction entrance, a crushed stone entrance at the beginning of the site. Again, the erosion control barrier being staked out all the way around our limit of work on the down gradient side of the work. We have temporary soil stockpile areas that are marked out. We have a temporary sediment basin, and we're showing that we'll have a temporary swale. All the water right now is draining that way. We're going to construct a temporary swale, so that any water coming down will be directed toward that basin during the construction phase of this project. I guess I'll flip it back to the grading plan, the colored plan here. I think it addressed most of the issues that have been brought up by the by the board. We certainly tried to address all of the issues that were raised at the previous meeting. I think the majority of John's comments have been addressed. The latest letter, we've read through it. I think we can address all of the new comments or the outstanding comments that he's looking for additional info on. But case here, we can really, what we're asking for is we're asking to waive down the road construction requirements so that we have a 16-foot wide roadway. And this is comparable to other projects that you've approved in town. This allows us to reduce the impervious surface within this sensitive area. In turn of reducing the impervious surface, we're reducing the runoff, we're reducing the size of the basin, you know, from that conventional density plan. And we're preserving, like I said, 200,000 square feet, 283,000 square feet of land, which will be designated for the town. I'll turn it over for you.
So basically what you've done is you're taking the cul-de-sac out, put a hammerhead in, and access driveways off the hammerhead.
Correct.
And shifted it slightly to the east from the no disturb line.
Correct. And then taking those.
If you didn't put a sidewalk in, could you shift it farther east?
If you didn't put a sidewalk in, if you did.
Didn't.
If you didn't put a sidewalk in, you could shift the road further to the east. It would be offset from the center line.
So you basically move it away from the non-disturb,
Correct. You could move it an additional,
3 feet.
yeah, 3 or 4 feet.
So how does the west side of the road, is it maintained?
No, it'll go back natural. On the lot plan. Anything out exterior of the right of way here, this is all just gonna go back natural. It's not owned by any of the properties. It's not owned by the homeowners association. It goes back as natural. It's non-disturbance area.
Is there anything that will delineate that for the homeowner?
Well, we're proposing bounds along this right-of-way and along this property line for the owner there.
But there won't be any kind of physical,
We weren't proposing anything, no. Maybe entertain something, you know, putting some posts there, some cedar posts or something to delineate that area if you want.
Stephen. Still Stephen. How did we do it on Elm Street? Didn't we delineate the areas in the back of the lots?
No, what we had is just the back corners of the lots are gonna end up being marked, but it's not like every 50 feet or something like that. Usually if it turns into a conservation issue, they do it along the 50-foot buffer zone for conservation.
But I remember the boundaries, I just don't remember what the spacing was. Thank you.
And if I might add, one of the other tremendous benefits of this plan, in my eyes, is the fact that all of this work is outside of the 100-foot buffer zone to a wetland. With a conventional layout, you're allowed to work up to the 50-foot buffer from a wetland, and we did utilize that area as part of the conventional density plan. But with this layout, we're not working within 100 feet of any jurisdictional wetland resource.
Before I get to you, Lance, I'm going to ask John, have you had a chance to review this?
Yeah, I believe this plan is the supplemental review that I sent in last week.
You want to talk to that?
Sure. Okay. So, if you know, my comment letter basically follows through again all the regulations. It starts with the flexible development under the zoning, and then where that triggers something in subdivision, it sort of flips into that. So as you know, the flexible plans, you have a lot of discretion as to what you are looking for. Obviously, there's a large area of land given to the town in the watershed, so that's a huge bonus. There are other issues that maybe aren't so huge. The street appearance will change dramatically and things of that nature. So those are things we should be looking at, I guess. And there's a lot of comments, but I'll try to key in on, I think, what maybe the major ones might be.
That'll be fine.
Okay. So site distance wise, I think what is important, you might have this view right now across someone else's land, but you have no control of it, and they could put up a fence tomorrow. What do you really have to the corner? I think that's critical. That, I know this is a tough spot to back out of because I did when I did my site work. There's several drainage calculation and things, issues there that I think mostly we can work out, but the biggest one I see is that from my review of the test pits, the dry wells don't work with the separation you need.
Okay. The dry wells for the roof?
Yeah.
Okay.
Now, my job isn't to design it, but I know there are alternative things you can use that maybe would work, but I don't think that the standard precast concrete drywall is gonna work. Groundwater's not that deep out here.
No.
Second, testing, there's been a bunch of soil testing done by various parties over the years on this project, but there hasn't been any testing witnessed by an agent of the planning board, which is required in the regulations. And there's no witness testing in the basin, so I think that's kind of important.
None on the roadway?
None in the roadway, none in the basin that were witnessed. I think those are things that give the board a little level of security that I think, should be in there. And this is not something I think that's difficult, but I'm kind of a stickler for it because I am the guy that's out in the field also doing the inspections. I'm not wearing the suit usually then, but I like to see that temporary structures for the erosion control. How many sheets is that? Two back, yeah. One more. I mean, basically, it's drawn as just sort of a shaded area. It should be designed as part of this because this is in a very sensitive area. We don't want them, if it's sized and if these features are designed completely on the plan so that they work, one, it makes my job easier, which is good because it costs them less money because I'm not out there and arguing what they have to do. Two, you don't have the problems. So it costs a little money up front to design it, and it probably saves 10 times that when the job's being built. So I think that is kind of critical. And again, there's a lot of very technical comments on the drainage and things of that nature that I think and there's a lot of little things that may or may not be on the plan that should be, I think, based on the regs. I know we're at 8:30 and I'm gonna do my best to not make it go too much longer, so I think that's kind of the key thing, and if you have any questions, or if the board has read the letter and have any issues of any of the comments I have, I think those are sort of the main ones.
Yeah, I think that captures pretty much any report. Okay. No, we gotta figure out where we're headed next. It's 8:30, we're scheduled to end at 8:30. Because we have a continued public hearing for 12 Marsh Hill, which we'll get to in a minute. Let's resolve where we are and what we need to do on this one first. I think we need to continue it. And I think we need to change the date for filing. Is that correct?
Yep.
You gave me all of that piece of information someplace.
Yeah, we have a motion, and we have... Who's got them? Okay.
It's the short one, Bill.
That would be this one?
Yes.
This one, Bill.
Having found it, why don't you read it?
Another example of no good deed going unpunished. I move to accept the applicant's request to continue the time for action for the definitive subdivision plan, flexible open space, special permit, and scenic road hearing for Fred's Way at 305 Country Way until August 28, 2013. Further.
I think that's a motion. We have to have that one, and then we move to accept.
Very good.
Is that,
Yeah,
is that acceptable to you? So what it does is it moves the time to file out, okay? And then once we've done that, then in effect, we'll look for the continuance.
Oh, that's acceptable, certainly.
Okay, so I need a motion to accept the
So moved.
extension. Do I have a second?
Second.
All those in favor?
Aye.
Now we have the next motion.
Very good. I move to accept the applicant's request to continue the public hearings for the definitive subdivision plan, flexible open space, special permit, and scenic road public shade tree hearing for Fred's Way at 305 Country Way until July 25, 2013, at 8:30 p.m.
Is that acceptable? Do I have a motion from the board?
So moved.
Do I have a second?
Second.
All those in favor?
Aye.
Okay, so we're now continued to the 8:30 and the 25th. I think you've got comments on the conventional. I think you got some comments on the flexible. And then on the 25th, you will have the 5th voting member. At that point, we can make a determination where we are with the conventional, where we are with. Okay, anything else? Thank you, gentlemen.
Thank you.
Okay. It's a tough piece of property.
It's really,
Yep.
it's really, it just feels like a two-house subdivision. With a shoehorn for three.
But I think there's a history that forces them into the third one.
There's what?
I think there's a history that forces them into the third unit.
Really?
Okay,
We'll have to do that one offline.
it's 8:30. The next item on our agenda is the continuation of the public hearing for accessory dwelling special permit for 12 Salt Marsh Hill. It's also a public hearing for a modification to special permit conditions number 3 and 4 for the flexible open space development at Greenfield Estates. You have an applicant?
I keep knocking this thing off. See, Bob's done a smart thing, he's just left it on.
I don't think he's noticed it's missing yet.
do you want to read that hearing notice on the special permit?
Do I have one of those too?
Oh, she's coming, yeah.
Hang on 1 minute, I've got a piece of legal
Jargon.
documentation to read here. Let's see it.
That's where his stuff.
You go.
Now I've got it. Okay. Allow me the opportunity to read the legal ad for the modification. In accordance with Mass General Law, Chapter 40A, Sections 9 and 11, and with Scituate zoning bylaws, Sections 550 and 940 referrals, the planning board will conduct a public hearing on the request to modify the flexible open space development special permit for Greenfield Estates dated 9/30/2003, as described below at 8:30 p.m. on June 27, 2013, in the Selectmen's Hearing Room, Town Hall, 600 Chief Justice Cushing Highway, Scituate. The request is submitted by Gregory Smith, owner of Lot 3 in the Greenfield Estates subdivision, known as 12 Marsh Hill Salt Marsh Hill Drive, assessors parcel number 55-2-3B. The subject of the public hearing is a modification of a previously approved special permit as follows. Modification of condition number 3 to add words, except for accessory dwellings subject to approval of the planning board, to the sentence, the total number of residential dwelling units on the site shall not exceed 4. Elimination of condition number 4, which states dwellings shall be sited in the approximate locations where they are shown on the plan. The footprint and upper story shall not
Should say exceed, I think, 2,800 square feet.
I don't have the page.
So, what are we looking at? Where are you reading that?
These are the original.
3 and 4,
Bylaws.
something completely.
I don't see the modifications. I read it online. I remember receiving the email and reading it.
You thought it was easy not having all this paperwork.
Okay, it's all this, it's all that stuff. So the front folder should have a legal ad.
Okay, okay. I don't suppose you'd want to read it off the newspaper. It'll be small.
Take those glasses with.
Okay, so it's here with these two
Okay.
pieces.
There we go. So let me go back and read item number 2. Elimination of condition number 4, which states dwellings shall be sited in the approximate location where they are shown on the plan. The footprint and upper story shall not exceed 2,800 square feet. The restriction of the total footprint area shall be recorded at the registry of deeds with each deed for each lot. The approved plans are available for review in the planning board office during normal business hours. Abutters and other interested parties are invited to attend the public hearing and offer their comments on the proposal. Signed by myself and published on 6/20/2013. Okay. I think we have now satisfied the legal requirement. The floor is yours. Identify yourself and
Hi, Gregory Smith, and my mother-in-law Eileen Scotty. So we're asking for the special permit for the accessory dwelling at 12 Salt Marsh Hill.
thank you. Laura, you want to give us background on it?
Well, when this subdivision was first approved, it was a flexible open space development, so there was a special permit. That's the subdivision that this property is within, and because of the desires of the applicant at that time, there were some pretty, particular restrictions put in to limit the size of the footprint, and also not to have any more dwelling units there than, just the basic 4. That was a number of years ago. Things happen, and people want accessory dwellings, sometimes for family. In many cases, it seems like a very, very positive thing to have those so that parents and grandparents can live in the same dwelling unit. And in order to get the special permit for the accessory dwelling, those conditions on the special permit have to be modified. So that's basically all I have to say.
I think that's brought us to where we were at our last meeting. We realized that in order to proceed with the accessory dwelling, we had to come back up and modify the special permit. That's the purpose of this meeting, is to modify the special permit. Any questions or comments from the board?
So the modification will allow for the construction of accessory dwellings?
Yes.
That's what we're saying here?
Well, it'll take away any obstacles from the town, whether there's a deed restriction out there or anything else, that's kind of a whole different area.
But it doesn't in any way impinge on our overview of the actual accessory dwelling application
No.
and all of
Yeah,
the
your
stuff
job.
we go through on the accessory dwellings.
Yeah,
And if we modify it, that will allow the accessory dwelling to be built,
yeah.
and,
Well,
Will
it'll
it
allow
also-
the application.
yeah, but ultimately,
Well,
if we
we'll
approve
allow
the application, it'll
to
allow
go
that.
forward.
So there won't be any restrictions on, other than what's in the current bylaws now, on the size of the accessory dwelling.
Now,
Well, you could limit it to the size that, the application is for. I mean, I think it's 930 square feet. I mean, you can limit it to that size.
Mhm.
But as things stand now, she can't even proceed with the application because there's a limit on the square footage of the whole house. And she
Right.
will exceed that.
Right. And the limitation on the square footage for the houses is 2,800?
Yeah.
So if we waive this requirement, does that affect the 2,800 at all?
Yeah, it takes it out.
Is it affected for all four
Does it, yeah. for
all
all-
homeowners?
Yep. Well, there's at least one home, I think it came up the last meeting, there's one home that's already at 3,000-something square feet.
Okay.
And, maybe that was just done without
Mhm.
knowledge of these restrictions, at least on the town's part.
Forgive me if I don't have information I should, but is there a homeowners association involved here?
yes.
Okay, and a representative from the association is with us tonight? Okay,
There's a couple.
okay.
A couple of homeowners or a couple of associations?
Couple of homeowners
within that
association.
Okay. And who's
We'd love to hear from you.
who's representing the homeowners association? Why don't you introduce yourself and tell us what?
Phil Santiano, 37 Greenfield Lane. I don't have a problem with the Smiths adding on. My only issue is changing the wording that I had to submit back in, I think it was '02 when we started the project, on the existing size of the homes and the height of the homes. And everything got recorded because I went by the bylaws that I was told to go by. By doing that, when I bought the project, it was to protect the views that I had of the harbor and the ocean and so on and so forth. So we went back and forth for about 2.5 years, trying to compromise with everybody, and that was the number that the planning board came up with. I believe it was 2,800 square feet, and height restriction was no more than 25 feet. By doing that, I had to go by it. I mean, I could have put up big McMansions and everything else. We didn't. Everything got recorded. Like I said, I don't have a problem with Greg building. My only problem is changing the wording that got recorded. I don't know how we go about that. It's all new to me. It got recorded to protect the views that I have in my existing home.
Mhm. Is-
So if Greg doing his addition is great, it's not gonna interfere with me.
Mhm.
My concern is, how about the other 3 dwellings?
Mm-hmm.
Am I opening up Pandora's box?
Is it a height issue or a spread-out type of
I
issue?
don't have a problem if he wants to go 4,000. My concern is a height issue.
Okay, so if the height,
That's my concern.
If the-
Greg,
No,
I see
I-
it. I wasn't here because I had no objection. I only have a problem with changing the wording that I had recorded.
Gotcha.
Thank you.
would your proposed plan, or what you've been thinking of doing, exceed the height restriction now?
No, it'd actually be lower than the existing house in all parts of the addition.
So it would be possible to change the square footage of the house requirement
Keep the
without,
height.
and keep the height.
The proposed motion makes no reference at all to height, so the existing height limitation would probably remain in effect.
Okay. Well, that seems important.
Should we hear from?
Any other
Yeah.
questions from the public?
I live at 8 Saltmarsh Hill, I'm Bob McCarthy. I've got absolutely no issue with the proposed project. And if there's one person in the association who would be most affected, it would be our house. So, I've got no issues.
Thank you.
Okay. Sir?
Larry Nyman, Ridgehill Road. I just had a question. What is the size of the house going to be when it's finished?
Do we have that? I don't know.
The addition will be,
3996?
yeah,
So almost 4,000 square feet. And was it recorded that the house couldn't be expanded beyond 2,800, what it was when you purchased the house? Wasn't that on the deed? Does anyone know?
I don't know.
We found some information on the deed that said that there is a limit.
I mean, I looked at the minutes, as Mr. Saniano referenced, you know, it came up at every meeting when this project was first proposed, and the public was assured there wouldn't be more than 2,800 square feet, and here we are 10 years later saying, never mind. Well, I don't know what's changed.
well, two of the houses on the street are well above 2,800 square feet currently.
So the board order was ignored?
Or the deed restriction was ignored. I don't know which, well, or both.
Yeah, us changing this condition won't change the deed restriction.
No. Absolutely does
I'm
not.
not sure I followed that.
I said us changing this condition won't change what's on the deed restriction that's been filed.
So it just applies to the special permit, but it does expand it to the remaining houses, is that right? So they could all expand?
Unless they have deed restrictions as well.
I'm sorry?
Unless they have deed restrictions as well.
They're separate limitations. Well, one is the one imposed by the town, and the other one that runs with the ground as a matter of real property law. We can deal with the things that the town does. We can't change the restrictions that run with the ground as a result of the limitation on the deed itself. We don't have the power to do that.
Okay.
And how does that get changed?
It's a long, complicated thing that takes lawyers and judges or an agreement with the property owners.
Can you give me a 30,000-foot, easy to understand for an old man answer?
Michael Haney, help me here. It's an action to clear title and ask the court to find equitable grounds under which you'd remove the deed restriction. Is that basically what you'd wind up having to do?
That would be one way.
Okay. And the other way would be to buy your way out of it by paying money to the master tenant.
That would be another way.
Okay.
I mean, there are a number of alternatives. I would say all of them are expensive and time-consuming.
And not very fun.
And not very fun.
Unless you're the lawyer.
Unless everybody agrees.
Who would need to agree, Mike?
Everybody.
All four houses?
The four houses that are bound by this deed.
Start, yeah.
Okay.
I mean, typically deed restrictions will indicate the restriction on the deed, and then you become the subservient tenant, or tenancy. And then the master tenancy is also limited there, and they're the ones that actually own that restriction.
Mhm.
Well, I think we've said this is only like one step in
Right,
the other things
right.
that they will probably have to do.
But we have 3 of those 4 homeowners in the room right now, all of whom have expressed support for this. So if what it would take is a 4th homeowner to also express support to clear the path, then maybe we're pretty close to that. Or we're not, but perhaps that's a close situation.
We can do our part, certainly, one way or the other.
Is there a reason why we should not modify it?
None that I'm aware of. You know, everybody seems to be in approval, and As long as we don't go up too high? Am I right on that?
I'm sorry?
As long as it doesn't go up too high, you have
Yeah,
no...
like I said, I had no objection
Yeah.
to Greg doing it, that's why I wasn't here the first go
I-
around.
I mean-
So, my concern is the wording.
Mhm.
I know I said that earlier. That's my only concern. My concern is the height. There is a house directly in front of mine that I just sold. It's 7 Saltmarsh Hill. I literally designed that low so that it could not actually be added on over the 25 feet. And if this happens to get worded differently, that could happen, and everything that I've done and what the town has asked me to do, it's thrown out the window. So as long as this gets worded, not higher than 25 feet,
To maintain the height restriction.
the height restriction, thank you.
Yeah.
I do not have an issue with,
And just to be clear, I don't have an issue with the in-law addition. My concern was really, why did we go through all that 10 years ago only to have it just thrown out? I was confused about that.
I wish we could tell you,
Thank
but
Director.
Wish we could answer that
none of us were here 10 years ago. We don't know.
Well, I think I was.
Laura was.
I was.
Laura was.
Well, I think it's just that, there's a new situation that wasn't, nobody imagined it back 10 years ago, that somebody would have a real need for an accessory dwelling who lived in one of these houses.
No, what it was is nobody wanted quote-unquote McMansions, and that's what they thought I was gonna be building. And some of the people in the room were those people. And that's the bottom line. So I did not build McMansions, and we have a situation, now what do we do?
Why don't we try a motion and see what happens?
Okay. Great.
Have motion will travel. I move that the planning board approve the following modifications to the flexible open space development special permit for Greenfield Estates subdivision. Number 1, modify the first sentence of condition 3 to state, quote, "The total number of residential dwellings on each lot shall not exceed 4, except for accessory dwellings subject to approval by the planning board." Number 2, eliminate condition 4, which required the footprint and upper stories not to exceed 2,800 square feet, and to record this restriction in the deed to each lot.
Now, that was added to retain the existing height restriction.
I've just looked all through this decision, and I don't see a height restriction in here. Okay, do you know where it is?
I don't have it here, I have it at my house.
Okay, I have it.
Steve, are you suggesting that's a restrictive covenant on the deed?
Yeah, it's right here.
Yeah.
It's number 2, Laura, on the second page.
There is a
Number, it's in the middle of paragraph number 2 on the second page.
Yeah.
Oh, there it is, yeah.
Of whatever document I'm looking at, declaration of covenants and restrictions.
Yeah, that's a deed.
We're not really dealing with that at all.
Oh, well, okay.
That's not our
Then why
issue.
is it in front of me?
Well, just to give you the information that
Okay.
something had been recorded,
Okay.
and that, it was against the deed, it should have been in the chain of title that, somebody probably would have picked up.
Got it.
So the answer to your question, sir, is we're not changing that at all, because we can't.
Correct.
But we can change the special permit that we granted.
Which didn't speak,
There's a
which
pending
didn't
motion to
speak
do
to
that,
height.
which doesn't speak to height.
Right.
Mr. Haney's asking a question.
Okay. Oh, I'm sorry.
I was just gonna suggest that, if it helps the applicants and it gets everybody what they're looking for, the amendment could include a 25-foot height restriction. So that there's no misunderstanding.
You want to amend it to reflect that?
Yeah, I would think that would make sense.
Sure.
Does that affect you, Greg?
No, not at all.
take it right out of here.
Yeah, why don't you just take it right out of, take the wording right out of that second paragraph there, because it references zoning bylaw language and things like that. Good stuff.
All right, I will reread this with the suggested modification. I move that the planning board approve the following modification to the flexible open space development special permit for Greenfield Estates subdivision. Number one, modify the first sentence of condition 3 to state, the total number of residential dwellings on each lot shall not exceed 4. I have a question.
What did we say?
Yeah, I have a question. It's,
It should, yeah, that doesn't sound quite right.
yeah.
I think something needs to be changed there. So that one was number
Number 1.
3. On the site, I'm sorry, it should say on the site instead of on each lot.
Yeah, that would be.
We want to say site, or do we want to say subdivision?
Okay, the subdivision is
Subdivision, right.
probably better.
When that was written, it was a single site, it probably hadn't become a subdivision.
Okay. All right, we're going to try now, number 3. All right. I move that the planning board approve the following modifications to the flexible open space development special permit for the Greenfields Estate subdivision as follows. Number 1, modify the first sentence of condition 3 to state the total number of residential dwellings within the subdivision shall not exceed 4, except for accessory dwellings subject to approval of the planning board. Number 2, eliminate condition number 3, which required the footprint and upper stories not to exceed 2,800 square feet, and to record this restriction in the deed to each lot. Number 3, add the following as an additional condition. And the height as defined in section 200 zoning bylaws of the town of Scituate of any structure shall not exceed 25 feet. So moved.
Now, does that solve,
I'd be careful with how you're referring to that height, because you're referring to the zoning bylaw, and you may just want to say it's a 25-foot height.
25.
But to where, Steve? Halfway up the pitch, the ridge, the eaves, you know?
Well, I mean, I would just look at it if you have your zoning bylaw up there to make sure it's going to do what they want.
You mean because
Isn't it
it's from
halfway
the
up the
average
slope?
grade and it's the average from the ridge to the peak?
Halfway up the
The
roof,
same
right?
thing that's written in the
distance
covenant and
measured,
restrictions.
From the average grade around the
I
foundation.
think one of the things Steve's looking at is this covenant restriction is 10 years old, and I don't know whether or not
It may be a different,
the bylaws changed in the interim.
it
Yeah,
has
the
changed.
height.
uh-huh,
It's definitely changed.
okay.
Because in our bylaw definition, height is defined as the distance measured vertically from the average finished grade of the ground adjoining a building to the highest point of the roof on flat, or for flat roofs, to the deck line for mansard roofs, and the average height between the eaves and ridge for gable, hip, and gambrel roofs. Except that in residential zoning districts, there should be a maximum height measured from the average finished grade to the ridge for a building with a gable, hip, or gable, gambrel roof.
I think that's probably sufficient specificity.
Does that still work, or does that not work?
Well, doesn't this work?
620.1. Just that in here, it says 35 feet. So you're using the same definition, but you're using 25 feet instead of 35 feet.
Yes.
Yeah.
As long as that's...
Yeah, we're
Right,
limiting it.
Measured per the bylaws requirements.
25 feet.
25 feet.
And that bylaw is now.
So
what,
5 years from now, I don't want to be sitting here saying, we're going to go along with third, not with Greg, with Joe Schmo,
Right.
going, so let's change it to 35 feet.
Just remember, the only constant is change.
So does the section of the bylaw change? Has it been rewritten with a different section number?
Never will.
I don't think she changed those section numbers.
No, it's section 200 under definitions. It hasn't changed.
Fine.
Or it's still relevant.
So I have a motion. Discussion on the motion? And that gives you the 25 foot.
Yeah.
Keeps, or retains the 25 foot.
front.
No discussion? All those in favor of the motion is read?
I didn't second it.
No, I'm sorry.
Second.
I'll second it.
Thank you. Okay, haven't been seconded, all those in favor?
Aye.
Okay. So we've now modified it. Is there an appeal period for the modification?
Yeah,
Yeah,
20
I think
days.
it's a regular special permit, appeal period of 20 days.
Okay.
Okay.
From when it's filed, after it's filed with the town clerk.
Well, you still have to vote the accessory dwelling too, and there'll be an appeal period for that.
Yeah, I just want to make sure that they don't have to be, they can be concurrent.
Yeah.
Do you want me to read that as well?
We prepared to vote for the accessory dwelling?
Yeah.
Before we do that, I have to read this. Once more, I read a legal requirement. Bob Green was not present at the 523 hearing, and under the Mullen Rule, which was adopted at town meeting in April 2013, a member can miss one hearing and vote if he's filed a certification that he's examined the evidence and testimony. This has been done and filed. Bob is now a voting member. Steve?
Is this locked into restrictive covenants through the planning board as well? So you're changing the decision, but you also have to amend the restrictive covenants at the planning board level? Because you
They're in.
accepted those when it was done. originally.
They're in the covenants and
I
restrictions.
don't think we
You
can
mean the
change the
covenant for the
restricted covenants.
subdivision?
Well, they give you the restrictive covenants when they went for the approval, and the board approves that. He's still gonna have to modify them at the registry of deeds and through the homeowners association. I'm just wondering, does the planning board have to take action on the restrictive covenants, to modify the restrictive covenants?
Is that what these are?
in line
That's what
with-
those
It
are.
already
that's
says
really-
25 feet is the limitation.
Yeah, the
In here.
planning board
But
didn't
but
have
it
any...
also says
Anything the
2,800
planning
feet
board
is the
expect-
restriction.
No.
Yeah, for the flexible open space?
This is the restrictive covenants, covenants and
To
restrictions.
modify the special permit.
Why don't you ask Mike, he's right back behind you. He was their attorney. Why don't you ask him?
Mike, do they have to also modify restrictive covenants as well as the special permit approval?
No, that would be up to the property owners to amend the.
So it wasn't part of the original filing. They didn't approve the restrictive covenants.
The board saw them, but my memory is, it was not part of the approval.
Yeah.
They saw it and reviewed it, but it was not part of the approval.
So then we're all set.
Mhm. Okay. I move to make the following findings of fact concerning the accessory dwelling at 12 Salt Marsh Hill Drive. Number one, according to the Town of Scituate Assessor's records, the property at 12 Salt Marsh Hill Drive is owned by Susan and Gregory Smith. Number two, on April 10, 2013, Susan and Gregory Smith applied for a special permit for an accessory dwelling proposed to be attached to the existing single-family dwelling at 12 Salt Marsh Hill Drive. Number three, according to the assessor's records, the floor area of the primary dwelling is 2,649 square feet. The floor area of the accessory dwelling as shown on the plan will be 939 square feet. With an addition of 432 square feet, the primary dwelling will be 3,996 square feet. The new accessory dwelling will be 24% of the primary dwelling with the addition which is less than 40% maximum in the bylaw. It meets the requirements of section 530.2F for accessory dwellings. Number four, the site plan shows a driveway and a garage for the primary dwelling. This appears adequate to provide 2 parking spaces for the accessory dwelling and ample parking for the primary dwelling. Number five, the property is located in the residential R2 zoning district on a lot of 19,406 square feet.
Is that it?
No. Number six, the applicant has submitted a signed notarized statement that she will live on the property. Number seven, the application meets the standards of Scituate zoning bylaw section 530 for an accessory dwelling special permit. believe these are the findings of fact that we have to make.
Do I have a motion to accept the findings of fact?
So moved.
Do I have a second? All those in favor?
Aye.
Okay. Decision.
I would propose the following decision related to the accessory dwelling special permit for number 12 Salt Marsh Hill Drive with the following conditions. Number 1, the applicant shall meet all requirements of the Building Department, Board of Health, Department of Public Works, Fire Department, Water Department, and other town agencies. Number 2, except for any changes necessary to meet these conditions, any construction shall conform to the plans entitled 12 Salt Marsh Hill Site Plan, L100 by OCO Architecture, Design Hingham, Massachusetts, dated April 10, 2013, and architectural plans dated March 10, 2013 by OCO Architecture Design, consisting of 9 sheets, A00, A100, A101, A102, A201, A202, A203, A301, and A401. Number 3, the property at 12 Salt Marsh Hill Drive shall contain a maximum of 2 dwelling units, the existing dwelling and the accessory dwelling as proposed. The footprint, number of bedrooms, and/or square footage of the accessory dwelling shall not be increased without prior approval of the planning board. Number 4, the owner of the property shall reside on the property as long as it contains an accessory dwelling unit. Number 5, the planning board will require an on-site inspection for conformance to the approved plans and these conditions prior to a certificate of occupancy being issued for the accessory dwelling. Number 6, no on-street parking shall be permitted. Number 7, the accessory dwelling special permit is approved, subject to a modification of the flexible open space special permit being filed at the Registry of Deeds for the modification of condition 3 and elimination of condition number 4 and the additional condition as enumerated earlier. Number 8, the owner shall provide an attested copy of this decision to the planning board office with a check for $76 within 30 days of the date of filing the decision with the town clerk, or resolution of appeals, whichever is later. For decisions which must be recorded in the land court, an additional $20 shall be included in the check to cover mileage to Plymouth. Number 9, the special permit shall lapse. This special permit shall lapse within 2 years from the date of its issuance unless substantial use or construction is commenced prior to that time in accordance with MGL Chapter 40A, Section 9. Number 10, the planning board reserves the right to review compliance with this special permit at any time. The special permit shall terminate if the use is not in accordance with its decision and its conditions. Number 11, at the request of the planning board, an affidavit shall be provided that either the primary or accessory unit is owner occupied. Number 12, at each transfer of ownership of the property, a new affidavit that the owner resides on the property shall be provided to the planning board.
So moved. Do we have a motion?
Seconded.
All those in favor?
Aye.
Okay. I would suggest you, A, thank your neighbors, and go ahead and start working on what you need to do, put your accessory dwelling in.
Thank you, sir. Thank you, guys.
Yes.
Thank
You may not know this, but this is the first accessory dwelling permit that we've done in some time where we haven't had the neighborhood up in arms. You are a blessed family. So throw a party and invite your neighbors.
But don't raise the roof.
I'll leave that up to them.
There you go.
Thank you.
Extend to Michael Hayes our appreciation for his help.
Yes, thank you.
Where am I now?
Frozen yogurt.
Yay.
Real property law is an arcane subject.
Yo girls.
We get samples?
Yeah, really. We got samples of the cupcake place.
Yes, we did. Yeah, but they didn't go through.
Let's be ready for samples.
With the health department.
Sure. Yeah, they
Okay, it's now Where am I?
Is that where flowers and festivities was?
I'm a little bit behind schedule, but the
think
next
so.
item on the agenda is a site plan administrative review for 100 Front Street. The applicant, come up to the table, introduce yourselves, and tell us what you'd like to do.
So my name is Costa Halos, and my mother and father-in-law, James and Sandy Stefos. And very excited to be here. We actually have a frozen yogurt business in Marshfield, Massachusetts called Creole Frozen Yogurt. And
I was there today.
you're there today?
Yes,
Man,
loved it.
maybe her. So we obviously want to bring a good thing to Scituate. Fell in love with the town, and feel like it's a great opportunity for us to come in and provide a great product and great service. What we've done for that community has been great. Feels like 10 years, but we've been there a year, and helping with fundraisers, charities, different things that we do within the community, and been very well received, and looking to bring it into Scituate.
Okay. So, we've received copies of your plans, so they're unchanged from your initial application?
Yes.
It's a site plan administrative review, so it's just a simple majority vote, no appeal process. And the site that they're proposing to occupy was previously where Flowers and Festivities was located. So when you look at the parking that was required for Flowers and Festivities, it's not completely scientific to me, but when you crunch the numbers, the number of parking spaces is no more for a 20-seat, little cafe, restaurant type of operation than for that retail, just because of the space that was involved and the parking standards in Scituate. So I think they are willing to have 16 seats rather than the 20, which might be a good idea, just to kind of see how things go. And they do show a couple of tables and chairs out on the sidewalk. The sidewalk isn't really something that the planning board has any jurisdiction over. A lot of the businesses do that. I think they probably get approved with those tables and chairs inside, and then I don't know what happens afterwards. That's kind of between you and the police department patrolling the sidewalk or doing whatever they do to make sure there's access. Some of them I noticed they're moved back along the building.
Indented area.
Yeah, or like Silent Chef, that area, they're right back against the wall of the building. I think that's just so they don't block the sidewalk. So just a thought with that. They've also gone to the trouble of getting a sign design. It sounded like it was going to be a fairly large sign. It was going to be 48 by 40 inches. But when you look at the mock-up relative to the other buildings, it looks like it would blend right in. So it looks like a pretty reasonable use, one that would increase foot traffic, which I think is obviously, well, I think everybody would agree is a good thing in the harbor.
Is there any change to the front facade? Is it changing at all? So it's
No,
the current configuration?
Yep.
With the big windows and all of
Uh-huh.
that I think at one time was the a five and dime.
Goddard's.
Was that Goddard's? Yeah. So,
Remember it well.
so that's where things stand.
Okay. Questions from the board? Comments from the board?
Just in terms of mechanical systems and all of that, is there anything that needs to change, or is it all part of the existing facility? Are you putting new HVAC in? Is all that's the same? And you don't need anything that's new refrigeration systems other than your cabinets and
Everything
stuff?
rolls right in.
Yeah.
As far as the refrigeration, there's no walk-ins, it's all
Mhm.
two-door.
And what's your hours of operation?
Right.
We'll obviously adjust seasonal as it goes, but pretty much the average is pretty much 11 a.m., noon, as
Mhm.
far as the start, and it goes till about 9, 10 p.m. That's really where the core business is.
So this would need Board of Health review?
Oh, yeah. Yeah. I think they're working on whether or not you're going to be required to put in a grease trap. The sewer system is pretty ancient in the harbor, and they try to keep grease out of it.
Yeah.
And all of the kitchen facilities would be inspected by the Board of Health.
And does this use any, I don't know, frozen yogurt places, will it use any more water or any other kinds of utility? It pretty much
It's a very
just
simple
washing
business.
things down and, okay.
Exactly. Simplicity of the business is what we like.
Uh-huh.
Even our products, no fat, low fat,
Yeah.
minimal issues.
And is
There's
it
no
all-
grease, there's no fries.
It's all delivered material? I mean, yeah, trucked in.
Yeah.
A lot of fruit shopping, as I recall.
For sure. Absolutely.
Well, I think it would be a great addition to Front Street. It desperately need to get some of those dark windows active, and really active at night, too. I mean, this would be great for that.
You're 2 doors down from that new restaurant that's gonna be going into where Finn's used to be.
Right. Right.
And so hopefully there'll be some synergy there from they to you and from you to them.
What's your schedule or timing?
Yesterday.
Before Heritage Days, right?
That's what we're working on right now. Is, we've done this before, which is obviously helpful. The plan is very simple, so we're hopeful we can open, 4-week timeframe.
Your suppliers are
Plus, there's no
all-
appeal period, so you don't. I had a question on the number of seats. It's 16, when the drawing showed 4 outside, and I guess the remainder inside.
I think four seats, correct, yes.
Okay. And so if we come back up, if we put 16, then we need to say, include the ones that would be inside. So you'd be entitled to 16, either inside or outside, inside,
Or
indoor,
both.
outside? However that needs to be.
Yeah.
But I'm sorry, I didn't really get the discussion about why 16 is the limit. If they had proposed something bigger, or is this
No, I
16
think
is what's
that's what they had proposed.
Okay. I thought you'd said 20 before, so.
Well, it looks like technically they could get up to 20 seats, but I think that's more than they want.
Okay. And the parking's street parking?
Street parking, Cole Parkway,
Cole Parkway,
people
okay.
walking.
Okay.
What's the delivery entrance on this building? Is it from the back? Is it like a common delivery
Probably be from
for all
the
the
front.
tenants?
Yeah.
Okay.
Yeah, everything goes in the front.
Curb Park, okay.
That Otis Place is a little bit crazy at some hours.
That's pretty
Yeah,
tough
sure,
there.
right, you're
I think they
right.
do use Otis as far as the deliveries, and they just walk up to the front.
Yeah,
Oh,
Do a lay-by.
4 o'clock in the morning.
it's, yeah, depending on the hours, there are times when Otis is blocked, except for one small lane. So I don't think you could get another delivery truck in there at certain times. You might want to talk to the people at Harborside Liquor and Silent Chef and find out what their schedule is.
I think this would be great, because I can get my yogurt and then I go over to the exercise place.
And watch.
I can't listen because we've made that virtually noise
Unless you're inside the
Yeah.
place itself.
Anything else? Any questions from the public? Do I have a motion?
I have a motion. I move to approve the site plan for Yogurt's Frozen Yogurt LLC, doing business as Creo, did I say that right?
Creo, yeah.
Creo, Frozen Yogurt Bar, 101 Front Street, property owner Spiros, did I say that right?
Yep.
And Kim, is it Mayos? Malios? Restaurant owner Kusani Stefos, almost. Cassiani. As an aside, one of my rules in life is that everybody deserves that name spelled correctly and pronounced correctly, and I try really hard.
You're very close.
As shown on a proposed floor plan and RCP for Cryo, frozen yogurt, by OCO Architectural Design dated June 13, 2013, at the scale of 1/8 equals 1, submitted with the application and attached to this decision with the following conditions. The restaurant shall meet all requirements of the Board of Health and other town boards and agencies. Number 2, the applicant or property owner shall provide the Scituate DPW a letter stamped by an engineer regarding the adequacy of the sewer pipes to serve the uses in the building. Number 3, the maximum hours of operation shall be restricted to a maximum of 11 a.m. to 11 p.m. Seasonal accommodation shall be allowed within the maximum range. Number 4, the restaurant's total number of seats shall not exceed 16. Number 5, the restaurant requires 4 parking spaces. Parking shall not be allowed in lots off of Otis Place, as this is parking required for the residential dwellings of 99 through 105 Front Street. Screening for the dumpster serving the building shall be maintained. Number 7, loading and delivery shall be provided in a manner so delivery trucks will not block streets, thoroughfares, or parking areas. Number 8, a hand-carved sign as submitted shall be used as signage for this restaurant. So moved.
Second.
Discussion? All those in favor?
Aye.
You got it.
Great.
You all
Thank
invited
you.
for yogurt.
There you go.
Thank you.
We'll see you very soon.
We'll be there.
We'll see you as soon as you open the doors.
Way too often.
Thank you.
Yeah, we may be down there before you're open.
Looking for you.
Thank you.
Thank you.
Okay.
Nice to have an
Now-
alternative to dribbles.
Almost on schedule. Next item is accounting, minutes, liaison reports, and town planner report. Not necessarily in that order.
All righty. I'm gonna swear you all to secrecy not to tell Richard I did this.
Richard has to review this and sign off that not only has he paid attention, but that he has comprehended what was.
Approved it, yes, I understand. I wish I didn't.
He may make a motion to have you the reader.
I'm going to begin to stutter. I move that we pay the following. The sum of $150 to Weston Graphics for the mounting of sea-level rise graphics for public display. Can I go through these all at once and have them
Sure,
approved as a
yeah,
group?
yeah.
Okay.
What is this? Or do we just,
That was.
Well, we were attempting to get that done out of this past fiscal year. We're right up against the deadline. I'm not sure we're going to be able to do it, so you may see that one again in July.
Okay. The sum of $126.40 to Laura Harbottle, mileage for March through June 2013, to the Gulf of Maine grant work sessions in Marshfield, $22.80. One Gulf of Maine interviews in Duxbury, looks like $12 even. June 6th to the MAPD conference in Lowell, Massachusetts, $43.60. To Land Court on June 26th, $18. April 1 through June 30th, site visits in Scituate for 305 Country Way, JW's Pizza, Deer Common, $30. And as I said, the total is $126.40. The sum of $52 to Karen Joseph, reimbursement for mileage to the Register of Deeds in Plymouth, 45 miles at 40 cents, plus $34 for planned copies totaling $52.
40 cents.
40 cents, wow, the federal's
Yeah,
55.
55 and a half or
Yeah,
something.
well, yeah,
Holy cow.
we don't live large.
You guys have small cars.
Talk to your
Get
accountant
gas
about the
efficient.
Big
difference.
cars.
Really?
All right, the sum of $60.38 to WB Mason for office supplies, file folders, labels, and pens.
do I have a second?
Second.
All those in favor?
Aye.
We'll sign these while you read minutes.
That'd be fine. These all from the same day?
Yep.
I move that we accept the Scituate Planning Board minutes for the meeting dated April 25th, 2013.
there a second?
Second?
All those in favor?
Aye.
Planners report?
Just a couple of real quick things. We're making very good progress on the economic development plan. We're using the money that was in this past year's budget for the Economic Development Committee. That's all getting paid, so that gets taken care of. We're also making some good progress on the open space plan, and the bills for that go to the CPC, so I'll be talking to you about that. I already asked them for a detailed bill because we're into the detailed bill mode now. And I just thought I would mention that Karen and I met with Pat Gallivan, who's the new conservation agent, and Carol Logue, who's the conservation secretary. We're looking at ways to bring together when we use our consulting engineer and they have like a kind of exotic or unusual, I should say, unusual environmental situation like the vernal pools on the Clapp Road development where they might need some special expertise. We're looking to bring that together, have one consultant do the whole thing, and it'll be billed, you know, the bills will be separated between conservation and planning, but it should reduce the consultants tending to kind of basically double bill for the same work to two different departments. Not that we've had a problem with that, but it's just, that's just something I think that crosses people's minds. So, so we're looking at kind of bringing that together, which I think will be a good thing. And then we continue to have our usual kind of mixture of drainage issues. We have I've had some complaints about some drainage over on Old Oak and Bucket Road. This is one where we had the stormwater permit. It was back when we were not using a consulting engineer for the review. It was built, but some of the slopes are a little bit different from what was on the plan, and the neighbor is seems to be getting some drainage problems. It's not clear whether they're from that construction or not, but we're looking at, you know, ways to put in a little depression to take some of that runoff off of him, and also to get an engineer to certify that, you know, no more runoff is going off the site than what was there before. So I think we'll come out okay with that one. You're going to be seeing one on the agenda, I believe, the next time at 61 Border Street, and it's another site, a little, not like 305 Country Way exactly, but there's a septic system, a little detention basin, a house, a driveway, all in a very tight area. And that one also, the site has a lot of ledge that's going to have to be blasted, and just a lot of issues. So that one we did send down to Amory to take a look at that. And they have to come into the planning board because the slopes are higher than what, you know, I can review in the office under the bylaw. You don't have to have a public hearing on it, so we were planning, we were thinking in the office that we wouldn't advertise it or, make a big thing out of it, but, it would come into the planning board for a review.
Anything else before we act on Bob's motion?
One item quickly. I've begun doing my background investigation into the idea of the medical marijuana zoning bylaw. Couple things. One is I'm not sure whether it's available on CNN's website. I hope it is. But there was a documentary recently done by Morgan Spurlock, who some of you may recall was the guy that ate at McDonald's every day for a month and nearly died. Anyway, he followed a medical marijuana dispensary in the Bay Area, which completely changed my preconceived notions of what these places were about. First of all, the cash flow in this place is horrendous. It's $75,000 a week.
Mm-hmm. All cash.
Yeah, all cash. Very technical, very sophisticated the way they run their business. There's also another documentary done on Channel 5 recently where they followed the medical marijuana dispensary proliferation in Colorado, where these places just sprung up like weeds. And in the years that have followed, there have been a number of them that have, most of them have fallen by the wayside and are now economic debacles. And so from that, and I would encourage, if you're able to find, you know, an online version to watch them, and we'll see a lot. So I think those are the things we need to take into
There's also an article in this month's Rolling Stone about marijuana, and particularly the dispensaries in Colorado.
Yeah. I wasn't aware of that.
Yeah.
I just got done reading the program minutes of a program put on by the Suffolk Law School with that, and I returned the book today. I've had a chance to read the proposed, I believe they're still proposed, I don't know if they're final yet, the regulations from the Department of Public Health.
Oh, really?
Yeah, they finalized those.
They're finalized,
Yeah.
okay. The version I read they were still proposed at that point.
Yeah.
My my thoughts would be that as we go through this process of getting this bylaw together, that we might want to consider having an informational meeting wherein we would invite the Department of Health, which seems to carry a big part of this, and then probably the police and maybe the people from the schools, in terms of where we should put things and so forth, and how we, you know, how they want to become involved. I'm not quite sure in my mind which of the regulations would be land use planning regulations, which would be Department of Health. I mean, it's very strict in terms of the form of the business that operates this. It has to be a not-for-profit. It has to be a Massachusetts not-for-profit. Reading the law just, or the regulation rather, literally doesn't look like they would allow an LLC, which I think is kind of interesting. Each facility has to have and that reminds me of one other thing we need to talk about. Each facility has to have affiliated with it a growing place. And so the question then arises, you know, are we not only going to have to have land use regulation for the dispensary, but also for an agricultural spot? Okay, and then we need to, and so we also need to talk to the people responsible for traffic, because there evidently needs to be restrictions on how these things are transported back and forth. And that's my report at this point. That's about as far as I've gotten.
Sounds pretty complicated.
If all you have to do is read, I can do it pretty fast.
I'll get the new issue of Rolling Stone.
But you remember too, that's key. I can read fast, I just don't remember.
Okay. Anything else? Bob's got a motion. Do I have a second?
Second.
All those in favor?
Aye.
We are adjourned.